All right, it's now 9:09 a.m. On Tuesday, October 15th, 2024. And I call to order this meeting of the Maine Gambling Control Board. My name is Steve Silver. I'm the board chair. Before we go any further, I'll explain circumstances under which we're meeting. Obviously, this is a hybrid meeting. The physical location of the meeting is 45 Commerce Drive in Augusta, Maine. We're also providing a virtual attendance option via Zoom in accordance with the board member remote participation policy adopted by the board on July 20th, 2021. The board expects that members of the public who attend the board meeting virtually will be able to provide public comment to the same extent as members of the public who attend in person. So if you're participating via Zoom, we'll mute your devices until it's time to talk. The Gambling Control Unit, on behalf of the board, posted notices of this meeting on its website with instructions on how members of the public could access the meeting. In addition, the unit, on behalf of the board, sends agendas in advance of the meeting to those that have requested to receive that. So hopefully everyone got them. First, I'll introduce other board members and confirm that we have quorum. When I call your name, identify yourself for the public by raising your hand. So it shows on video if you're on with us via Zoom. So I'll start to my right, Chief March.
Good morning, everybody. My name is Noel March. I'm a resident of Hamden, Maine.
Mr. Hanslip.
Good morning, Joe Hanslip, Sanford, Maine.
All right, Ms. Bickmore on. Okay. And my name's Steve Silver from South Portland, Maine. So we've got 3 members present, which constitutes a quorum. I will note, before we jump into the agenda, that board member Sari Green has resigned her position as of October 8th. She served on the board for about 3 years, I think. So we thank her for her service, and certainly there's now a spot open to the extent you all know anyone who might be interested. We can, there's information on the governor's website about how to apply, or you can talk to me or Director Champion about that. So with that said, we'll go to the approval of minutes from the August meeting. Any issues, edits to be made? And I think, yeah, go ahead, Mr. Hanslip.
Motion to approve, Hanslip.
Thanks. Were you there, Chief March? Yeah.
Yes.
Okay. All right, I'll second that. Any discussion needed? Okay, let's take a vote. Chief March?
Aye.
Mr. Hanslip?
Aye.
I'm an aye as well. So those are approved. And with that, we will turn to Executive Director Champion for the operations report.
Okay, and before I get started, I was a little late getting this out to you in the past week. But honestly, what I'm looking for is to be able to give you as much information as you can in order to make decisions. And so a little bit of change in reports may exist, from month to month until we get it down to where we want. But if there's anything that you specifically want as far as data or anything, just let me know and I'll include it. So for operations in August of 2024, there were 17 shipments of machines and or associated equipment shipped to or from licensed facilities. In September, there were 5. There were 72 work orders completed in August and 25 in September, which ranged from new game installs, removals, changing themes, options, and communications issues. There were 96 entries in the inspector pass-on log in August and 53 in September to share information, not only from within the facility, but also between the facilities. There are currently 10 formal complaints with status updates and are reported in the complaint dashboard. 1 is pending referral to the board and the consent agreement. 1 is under review by the complaint committee. 1 was dismissed by the director. 1 is under review by the investigative committee. And 1 was issued a letter of guidance. 4 are awaiting a response from facilities, and 1 continues to be under investigation. And I hope that totals 10. There were no minimum or no minor activities observed by the unit to continue to monitor for the development of any trends. There were no patron complaints, and there were 21 self-exclusions in August and September, 15 1-year, 0 3-year, 4 5-year, and 2 lifetime. The total as of September 2024 is 107 1-year, 45 3-year, 54 5-year, and 376 lifetime. We were able to get some information from Oxford PD. Oxford PD reported 17 calls in August and 17 calls in September. There were 6 arrests, 1 banned patron, 4 for illegal activity, 6 medical responses, 2 suspicious activities, 9 possible intoxication, and 3 undesirable conduct. And as stated, I'm working with Bangor PD to start to get their calls as well. And that's my report.
Okay, thank you. Any questions for Director Champion?
Bill, can you just remind me who constitutes the complaint committee?
That would be the commissioner, assistant commissioner, assistant attorney generals, and myself.
Thank you. Heavy hitters. The complaints better be good.
Milt, I have to go back through, but at least in the past few months, it seems like self-exclusions are up per month. So, I mean, I feel like when I started, we were at 1 or 2 a month.
Yeah.
Now we're, 7 to 10 a month, it seems like.
Yeah, I mean, I have, the last time I pulled together some data, we had, it was in reference to the days of the week, but, yeah, they, some months obviously are more than others, and we can only surmise that it might be around tax time,
Yeah.
financial hardships and that sort of thing, but yeah, it's.
And is this total or is it just at casinos?
No, this is total. This is total. So this would be, now it does, but it doesn't include like sports wagering,
Yeah,
which has only been 7 since November 23. So really that's, it's not a lot.
Okay.
But yeah, this would be anyone either online at the casinos, at a AdCare substation or sub office, whatever you refer that to. So it'd be from all those entities, yes.
All right. Any other questions for Director Champion on this portion? Okay. Let's turn to the next item on our agenda, which is the financial report from Auditor Amanda Spencer.
Good morning. This is the financial report for the months of August and September 2024. Total tax revenue paid from both casinos to the state of Maine decreased by 8.82% or by over $566,000 in August, and decreased by 9.49% or by over $585,000 in September 2024 compared to the same months in 2023. 2024 year-to-date tax revenue collected from the casinos was over $51 million in September. This was a decrease of 5.31% or by over $2.8 million compared to the same time last year. Specifically by casino, the Oxford Casino reported a total net win from slot machines of 6.87% in August and 7.01% in September 2024. Reported total win from table games was 11.37% in August and 23.79% in September 2024. The Hollywood Casino reported total net win from slot machines of 8.27% in August and 8.02% in September 2024. Reported total net win from table games was 20.72% in August and 23.18% in September 2024. Regarding advanced deposit wagering, we observed a decrease of 0.5% for August and a decrease of 16.8% in September of 2024 compared to the same months in 2023. 2024 year-to-date tax revenue collected from in-state and out-of-state races was over $165,000 through September. This was a decrease of 8.9% or by over $16,000 compared to the same time last year. And that completes my financial report. There are any questions?
Any questions for Ms. Spencer?
It seems like the revenues are down quite a bit over the course of just 12 months. Does anybody have any insight as to what might be impacting, be able to turn it to the companies?
Less COVID.
Yeah, we're ramping down from the COVID highs. In August, we did have several progressive jackpots on both tables and slots, $200,000 range. Did impact the revenues there. September was a little more consistent with prior.
Thank you. Anyone else have any thoughts or? Okay, thank you.
Less free money floating around.
Good.
More competition.
Do you think sports betting has had an impact? So there's only so many gambling dollars in a small state. Okay, we'll keep an eye on this. Thank you. All right, let's go back to Director Champion for the Executive Director report.
Okay, good morning, everyone. So advanced deposit wagering rules were adopted by the Secretary of State's office on October 8th. Also, our website was updated to identify areas of oversight to include casino, ADW, fantasy, sports wagering, and charitable. We're going to be making additional changes by separating into each one of those sections. As you click on that section, you'll have a drop-down menu. We're going to separate out rulemaking for each section. I just think that'll work out a lot better for us. And I think as of right now, I think we have three potential applications, or at least 3 inquiries for ADW operators. So we'll be processing those as they come in, but we're getting some interest, and we've had interest leading up to the adoption. And the following is to kind of serve as an FYI, with the understanding of being able to add legacy lists with the passing of LD 2080. We added those lists to the state list. In doing so, a letter was drafted to notify those on the legacy list. Specifically in the statute, it says establishment of a universal list of persons who have been or are requested to be excluded or removed from any slot machine facility, casino, advanced deposit wagering, fantasy contest, or sports wagering in this state, including those persons who voluntarily request that their names be included on the universal list of excluded persons, and those persons who voluntarily requested that their names be included on a list of persons to be excluded and removed that existed before the establishment of the universal list. Rules adopted under this paragraph must be consistent to the extent possible for all forms of gambling, including on the universal list. So we exchanged legacy lists, and with that, I asked for a legal review of a letter of notification, and it was determined that the legacy list cannot be included in the universal list because they are only excluded from specific properties. So essentially, we're back to square one with the 3 list. I reached out to both casinos, and while I've been waiting for a response, I did have a chance to talk to Matt before the meeting to see for either those legacy lists would be able to have alerts specific to a property or notifications to identify these individuals that are excluded from a specific property or the state list. If that mechanism is too cumbersome or time consuming, then we will delete those from the universal list altogether and move on. I bring this up in my report this morning, again, as awareness and not looking for direction from the board we will collaborate the position with the casinos and move on. And like I said, I did have a chance to talk to Matt a little bit this morning before we started the meeting. And they're looking at taking or removing those from the legacy list from Hollywood. They're going to remove it from their database. And so I will confer with Hollywood and see if they'll do the same thing. Roughly number wise, it was, I think, 129 that were added. And since we did the adding, there was about 6 or 8 people that actually reached out to us and explained, they wanted to know the rationale for the change. And so, again, this legacy list, as you well know, we've sent out at least 2 or 3 letters to everybody on the legacy list, and we get roughly about a half a dozen, but no more than a dozen responses due to addresses wrong, or maybe the person's deceased, right? Because these are only lifetime exclusions. They would have expired, going past their term. So we're going to work at drawing those back out, and we'll just continue to work with the 3 lists going forward. Okay, that's my report.
Any questions for Director Champion? I have a question that may or may not be related, but I get asked and I don't know the answer. Maybe you do, or it needs research, but the new sports book that opened in Portland, right, which is on a commercial track license. The question I guess is, how's that possible? And then 2, if there's a facility license like at one of the casinos, can't they just take that license and open up a sports book wherever they want?
Yeah.
If you don't know the answers offhand, that's fine. You need to do research, but
Yeah.
I don't know how to respond when,
Currently, the application's under review. I understand that that establishment has received a temporary license, so they haven't received full licensure yet. So I think it would be best to not discuss eligibility because that's still being determined right now.
okay. Yeah, it just seems like if the license isn't tied to, the track, then, I think that the facility operators that may or may not be casinos may want to come before the board and ask for some guidance or direction about opening up a sports book wherever they want. Seems like if that's what the state wants to do, then perhaps we should permit it. We'll leave that to another day.
And again, that whether that's possible is still under review.
Well, it's open.
It's open, but it's still under review.
There's a sports book in the old port in Portland, and
Yes.
folks are wondering, how's that possible? When the law said it was supposed to be at a commercial track. So, if it doesn't have to be at a track, in my mind, it doesn't have to be at a casino. So the folks at Oxford want to open up a book in the old port, or come across the bridge to my neighborhood in South Portland, maybe we'll talk. So something that folks are concerned about, whether you've heard it or not. All right, the other question I had, which I think the commissioner's here to address, just an update on where we are with the inspectors and, how things are progressing.
Yes, good morning. Mike Sostruck. I'm the Commissioner for the Department of Public Safety. I think this is the 4th meeting in a row that I've joined you. So I do appreciate your time, your energy, and your hospitality. To touch on very briefly, the licensing question that you did ask, Mr. Chair, is something that we are actively reviewing, as Bill had mentioned and Bill had supported. So we're definitely taking a look at that. I would expect us to have some kind of finding on that relatively soon. So I appreciate that. And also appreciate your time to just get updated a little bit. So on September 4th, the public safety inspectors at the casinos issued a letter of voter of confidence on Director Champion. And then on September 5th, the remainder of the Bureau, there's 9 inspectors, and then there were 9 employees in the remainder of the Bureau issued a letter of confidence in Director Champion. The reason I mentioned that at all is because a couple of things in the voter no confidence that I wanted to highlight. One around pending grievances and the other around impact bargaining. And while the grievance process is largely designated by statute and union contract, Milt would have eyes on grievances as they work their way up through the system and impact bargaining from the state perspective. Both of those things end up with human resources and they end up with the employee Office of Employee Relations. So I can tell you without getting into details that I've had conversations with HR and employee relations about where those are in the sense that it is an active negotiation between the union and the state. Those aren't things that Milt can drive or that at this point he's directly involved with. So I wanted to highlight that. And I think there are other, concerns behind the scenes with personnel matters that we don't discuss in this setting and haven't. So while that update, I guess, is very brief, what I would say is that I think the communication between the leadership team and the inspectors has certainly been enhanced with those monthly visits to the casinos and sitting down in person across the table, discussing ongoing operational concerns, seeking input directly from the inspectors, boots on the ground in those facilities. I also want to say thanks to the casinos and everybody's work, because I do think from an operational standpoint, things are progressing very smoothly. And that's the primary reason I wanted to mention these letters, because if you just read those from the outside, you may think, well, geez, what's happening? You may think that anyway, but from an operational standpoint, I think the various processes that have been put into place, whether those are email addresses, work orders, things of that nature, are working and have been effective. So I'm not sure I'll be able to answer any questions, but you always offer the opportunity. So if you got anything specific that I could either do some homework on or try to answer now, I'm happy to do so. So thank you to the board. Thank you to the casinos for their flexibility and their willingness to work with us through this process.
Thank you. Any questions for Commissioner?
I'm just kind of curious what the staffing schedule looks like now. Last time we spoke, we were speaking about Sundays and Mondays being off and so forth. How do we stand with staffing today in terms of its?
The schedule is exactly the same as it was during our previous conversations, and the staffing levels, as in all of those positions, are currently filled as they have been for quite some time.
But we still have a Sunday, Monday
Correct.
off
Yep.
schedule.
Correct.
And how's that been going?
Well, as I just stated, I think operationally, I think that's working just fine with work orders and the email addresses and the changes that we've already implemented. I think that's looking at that rule again today, that things have been very smooth.
And I take it the sort of personnel process is not up to you or Director Champion. Like, this is the length of it. I mean, the HR is handling this.
Yeah,
Yeah.
I mean, the reality is that I rattle cages periodically to say where are we at with these things, and whether or not that's effective to move things forward. I know that HR and Office of Employee Relations are incredibly busy, and it does take two to tango, right? You send a response, you wait for a response, and so if there are delays, it's not just a state issue.
Yeah,
it's waiting on responses in both directions.
Yeah. And I'll say, and you don't have to respond to this. I learned about things through the media. So
Yeah.
I don't appreciate whether it's for all parties, right? Come to the board or contact us. Like, if you're going to put out these things in the public in a letter and not even, provide that to the board, that just seems silly and not productive. And it sort of has frustrated me. This isn't directed at you.
Sure. Yeah.
It's directed at the two things you mentioned, the letters and
Right.
whatever. It seems like a publicity stunt and not actually about what may or may not be happening. And that's how I view it, because you're not sending this letter to myself, and I understand you may not have even received it for a while.
Yeah. I got it 5 days after it hit the media.
Yeah.
And I'd received, dozens of media requests to say, can you respond to this? And, we were consistent to say, I haven't received it officially from anybody. So when they did finally ship it, I think 5 days after the fact, that then we have it in our, in our possession.
Yeah, it just makes me feel like if there's a problem, you're gonna come to us. And if it's not really a problem, and you want to do a publicity stunt, you're gonna do what happened. And so that doesn't sit well with me. You don't have to respond to that. It's my comment, but,
I would also say on the, just as an overarching comment, I guess, is that, you get a letter of no confidence, and that got dozens of stories and dozens of media outlets, had a story on that. A letter of confidence had one story, and that story was only because we had reached out to that reporter, to be quite frank about what I think was inappropriate, reaching out to Director Champion for comment. And the way that went down, we reached out to say I didn't think it was appropriate. We didn't appreciate it. Then we had, so I think after that, we had one positive story from that particular reporter, and that's the nature of the world we live in, but that doesn't make that right either. So
Yeah. All right, and just day to day, moving forward, everyone's getting along? Is that your impression?
yes, and I
Okay.
think that impression is based on, people are continuing to do their jobs, right? They're doing the work, they're having input. And, as far as the number of work orders coming in and trying to figure out those days, as we get into that, I think that's going to smooth out even more and more as everybody understands, what the situation is, depending on the rule and whatever the final outcome is. I think that's going to continue to get better and better.
Any other questions for Commissioner? All right, well, we appreciate you being here.
Yeah, absolutely. And my apology, I'm going to have to leave at about 20 minutes to head over to the State House, but I will hang out.
No
Good to see
problem. And certainly I'll let the casinos know. I mean, you can tell us if there are problems, operationally, whether at a meeting or send an email. Like, we don't know. Nobody tells us. So,
And they can certainly do the same with me, Mr. Chair. And as an example, the makeup of the complaint committee resulted from, weeks of conversations between me directly with the casinos back in the day, talking about that complaint process. Milt, the AG's office, and all us working, because we wanted to set eyes on these complaints as they were working through the system. So the door is absolutely open and all the time. So I do appreciate you allowing me to attend and speak,
Yep.
Mr. Chair.
all right. Moving along, we've got a couple licenses, one initial, 2 renewals, to go over, and just one general point, note. Some of the licensee information contains like social security numbers, addresses, dates of birth. Is there a way we can redact that before they're loaded into here? Just because these iPads are old and not secure, and Dropbox itself is, right, 50/50 as to that level of security. So, I think just before they're uploaded digitally, we just redact that stuff. It's just another level of protection. So,
Yeah, I'll take a look at those again. So these are business entity applications. They have like org charts and stuff like that. So I'd have to really dig in to see, because there's no like individual applications
well,
being submitted, but that's not to say that there's not a social security in there somewhere, but.
I mean, these 3 did a good job of sort of, on their applications, the different portions of it.
Right.
And, they're listing individual executives and stock owners, and it has their dates of birth and social security numbers. So,
Okay. I'll double check on it.
it's more just that if we're uploading it digitally to the Dropbox, and then it's on 5 iPads that are traversing wherever they are.
Yeah.
Not, we don't want to be the ones responsible for
Yeah.
something happening. So, I think that's just good practice moving forward.
Yeah.
All right. So, with that said, we will turn first to the application of AGS LLC for an initial license as a small slot distributor. This is not an adjudicatory proceeding. Instead, we'll be receiving an opinion from board staff supported by evidence obtained during investigation. We'll also provide the applicant with an opportunity to be heard and the public an opportunity to be heard. So the applicant seeking a license as a small slot distributor is AGS LLC. Is there anyone here on Zoom from AGS?
Yeah, good morning. Brandon Griffith. I'm the compliance officer for AGS.
All right, thank you for being here. We'll come back to you in a second. But before we proceed, I assume Assistant Attorney General Mantis has some questions for us.
I do. Does any member of the board have any reason such as personal bias or conflict of interest that would prevent him or her from rendering an impartial decision in this matter?
So, no, but I'll just disclose, because the first time this has ever happened, every single applicant today, turns out has been or is a client of my firm. Not of me or my office, but doing employment work in other areas. So
And that law firm is.
Littler Mendelson.
Thank you.
So just putting that out there, I don't know much about any of these entities. I don't do work for them, but I do run a conflict check every time we have an entity. And this just happens to be a day where all three show that they've used our firm at some point. So just putting it out there.
For the record, thank you. Does any other person present at the hearing believe that there's any reason that would prevent any board member from rendering an impartial decision in this matter? If so, please raise your hand or raise your virtual hand, state your name for the record, state your objection for the record, and the basis for that objection. Seeing none and hearing none, if there are objections to any pre-hearing proceedings, that is the procedure of this case. At this point, please stand or raise your virtual hand, state your name for the record, state your objection and the basis for that objection. Seeing and hearing none, Chair, you may proceed.
Okay. And each board member has received copies of documents the board staff is relying upon to support its opinion. Those documents will become part of the record. The complete inspection has been made available to the board. Copies of the public portion of these materials are available. So if you want a copy, please speak with Director Champion and he'll arrange to have those materials provided to you. Any other evidence such as conclusions of the board staff, information provided today by board staff, statements made, or documents provided by the applicant in public comment will become part of the record. With that, I'll turn it back over to the representative of AGS. I don't know if there's anything specific you want to say. If not, I'll ask the board if they have questions for you.
Nothing specific. AGS, while this is an initial license for the small slot distributor, we have been a licensee with the Gaming Control Board for, I think, since 2017 as a table games distributor. So hopefully we are a known entity to your organization, and I look forward to the opportunity.
Okay. Any questions for the representative from AGS? All right. With that, Detective Armstrong on?
No, actually, I did the initial.
You did it? All right. Sure. Go to Director.
They'll take the renewals. So AGS LLC's Ms. Carol Castro, licensing manager, applied for an initial small slot machine distributor license on September 9th, 2024. AGS LLC currently holds a table game distributor license in Maine. They disclosed in their application was evaluated by whether the applicant satisfies the criteria outlined in 8 MRSA's Chapter 31, to the extent to which, if any, the applicant will be subject to the control or influence of its activities by any person having a financial interest pertaining to the applicant, including a mortgage or other lien against property of the applicant, or who, in the opinion of the board, might otherwise influence its activities. In such case, the director shall consider the character, honesty, integrity of whoever has the ability to control or influence the activities of the applicant. The degree to which the applicant has demonstrated its ability to finance the proposed small slot machine distributor operations, as well as the source of such financing. The degree to which the applicant has supplied accurate and complete information pursuant to requirements of this rule. The extent to which the applicant has cooperated with the board and department in connection with the background investigation. Whether the person or any of its officers, directors, partners, owners, key executives, or small slot machine distributor employees are known to associate with persons of the various backgrounds or disreputable character. With respect to any past conduct which may adversely affect upon the applicant the nature of the conduct, time that has passed since the conduct, the frequency of the conduct, and how extenuating circumstances that affect or reduce the impact of the conduct or otherwise reflect upon the applicant's fitness for license. Any other information before the director, including substantially similar background investigations carried out by other agencies or jurisdictions that relate to the applicant's competency, financial capability, honesty, integrity, reputation, habits, or associations. Federal and state tax returns for 2022 and 2023 were submitted. Those financial documents and other documents as required were supplied to our financial review contractor, Whipfly. Whipfly reported that the company AGS LLC appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives for AGS LLC were found to have demonstrated financial responsibility as defined by regulations governing the board. AGS LLC and its principals meet the qualifications of Title VIII, Section 1016, numbers 1, 1A, and 2, and Section 1019. AGS LLC also meets the requirement of Board Rule Chapter 2, Section 3. AGS LLC shall be licensed as required under Title VIII, Section 1013-2, which states that the board may issue a license to distribute slot machines to an applicant that meets the qualifications set out in Sections 1016 and 1019. Therefore, after verification of the documents submitted, an interview or inquiries by Detective Armstrong, and the financial review by Whipfly is the opinion of the department that AGS LLC is suitable to be licensed as a small slot machine distributor in the state of Maine.
Thank you. Any questions for Director Champion? Okay, any public comment on this application? Anything on Zoom? Okay. All right, is there a motion on the application of AGS LLC for initial licensure as a small slot distributor?
So move, March.
Seconded, hand slip.
Thanks. Any discussion needed? Okay, let's take a vote. Chief March,
Aye.
Mr. Hanslip,
Aye.
I'm an aye as well. Having met all the requirements of licensing pursuant to Title VIII, Chapter 31, AGS LLC will be licensed as a small slot distributor in the state of Maine. And we thank them for their continued desire to do business in Maine.
Thank
So
you.
with that, we will move on to the next. This is a renewal license application. And this is of Cummins Allison Corp. For the renewal licensure as a gambling services vendor. Once again, not an adjudicatory proceeding, instead we're receiving an opinion from board staff supported by evidence obtained during investigation. We'll give the applicant and the public opportunities to be heard. Is there anyone here from Cummins Allison? Wouldn't think so. Okay. Seeing no representative, we'll turn back to Assistant Attorney General Mantis.
Thank you, Chair. Does any member of the board have any reason such as personal bias or conflict of interest that would prevent him or her from rendering an impartial decision in this matter? Seeing and hearing none, does any other person present at the hearing believe that there is any reason that would prevent any board member from rendering an impartial decision in this matter? And if so, please stand or raise your virtual hand, state your name, the basis for that objection, and your objection. If there are objections to any pre-hearing proceedings, that is the procedure of this case up to this point. Please stand or raise your virtual hand, state your name for the record, the objection, and the basis for that objection. Seeing and hearing none, Chair, you may proceed.
All right, and again, if any member of the public wants the public portions of these materials, please contact Director Champion. We will turn over to Detective Armstrong for this one.
Yes.
Pursuant to Title 8, Section 1005, Subsection 2 of the Maine Revised Statutes, the Department of Public Safety is responsible for investigating the qualifications of each applicant before a license or registration is issued and reporting to the board the results of any such investigation. Cummins Allison Corp., Mr. Charlie Sewell, Compliance Manager, applied for renewal of the company's gambling services vendor license on August 5th, 2024. The company disclosed, and it was verified, that since the company's last application for a board license, There have been no changes to the company's address. There have been changes to the key executives of the company or any parent or intermediate affiliates of the company. There have been changes to the ownership structure of the company or any parent or intermediate affiliates of the company. There have been no adverse actions taken against the company or any parent or intermediary affiliates of the company by any other regulatory agencies, and there are no charges pending against the company or any parent or intermediate affiliates of the company in any state or federal court. The company submitted its federal and state tax returns for 2023. Those financial documents and other documents are, as required, were supplied to our financial review contractor, Whitfly. Whitfly reported that the company, Cummins Allison Corp., appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives for Cummins Allison Corp. Were found to have demonstrated financial responsibility as defined by the rules governing the board. The department has investigated the qualifications of Cummins Allison Corp. And has determined that it meets the board's requirements for renewal of its gambling services vendor license. Specifically, Cummins Allison Corp. And its principal continue to meet the qualifications for a license set out in Title 8, Sections 1016 and 1019, and meets the requirements of Board Rules, Chapter 2, Section 5. Therefore, after my verification of the documents submitted, interviews or inquiries, the financial review by Whitfly, and the final review by Director Champion, it is the opinion of the department that Cummins Allison Corp. Is suitable to be continually licensed as a gambling services vendor in the state of Maine.
All right, thank you. Any questions for Detective Armstrong? Okay, any public comment on this application? None in the room, any on Zoom? Is there a motion on the application of Cummins Allison Corporation for renewal licensure as a gambling services vendor?
Motion to approve hand slip.
Thank you.
Second, March.
All right, any discussion? All right, let's take a vote. Chief March,
Aye.
Mr. Henslett,
Aye.
I'm an aye as well. Having met all the requirements of licensing pursuant to Title 8, Chapter 31, Cummins Allison Corporation will be licensed as a gambling services vendor in the state of Maine. And of course, we thank them. Yeah.
There is someone named Kelly's iPhone. I don't know if it might be Kelly.
Yes, I'm here as well.
Yeah.
For the minutes, she's with us.
Just so you know.
All right, we'll bring her in on the next vote.
But does she have that video?
It's not required, but
Okay.
it's
Just wanted to check.
highly recommended, but there needs to be a roll call vote.
All right, moving along. Our final renewal application is Interblock USA LLC as a table games distributor. Again, this is not an adjudicatory proceeding. Instead, we'll be receiving an opinion from board staff supported by evidence obtained during investigation. We'll also provide the applicant and the public an opportunity to be heard. Is there anyone here from Interblock USA? All right. Before we proceed, turn it back to Assistant Attorney General Mathis.
Thank you. Does any member of the board have any reason such as personal bias or conflict of interest that would prevent him or her from rendering a partial decision in this matter? Seeing and hearing none, does any other person present at the hearing believe that there is any reason that would prevent any board member from rendering an impartial decision in this matter? And if so, please stand or raise your virtual hand, the objection and the basis for that objection. Seeing and hearing none, if there are objections to any pre-hearing proceedings, that is the procedure of this case up to this point, please stand or raise your virtual hand, state your name for the record, state your objection and the basis for that objection. Seeing and hearing none, Mr. Chair, you may proceed.
Okay. And I'll just say too, for all three, it's nice to have the new application. They put in a description of what they do.
Yeah.
It's helpful. So that looks good. All right. Seeing as there's no representative of the applicant, we will turn it back to Detective Armstrong.
Pursuant to Title 8, Section 1005, subsection 2 of the Maine Revised Statutes, the Department of Public Safety is responsible for investigating the qualifications of each applicant before a license or registration is issued and reporting to the board the results of any such investigation. Interblock USA LLC, Miss Nicole Fortier, Compliance Manager, applied for renewal of the company's table game distributor's license on August 8th, 2024. The company disclosed and it was verified that since the company's last application for a board license, there have been changes to the company's address. There have been changes to the key executives of the company or any parent or intermediate affiliates of the company. There have been changes to the ownership structure of the company or any parent or intermediate affiliates of the company. There have been adverse actions taken against the company or any parent or intermediary affiliates of the company by any other regulatory agencies, and there have been no charges pending against the company or any parent or intermediate affiliates of the company in any state or federal court. Company submitted its federal and state tax returns for the preceding year 2022 and 2023. Those financial documents and other documents as required were supplied to our financial review contractor, Whipfly. Whipfly reported that the company Interblock USA LLC appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives for Interblock USA LLC were found to have demonstrated financial responsibility as defined by the rules governing the board. The department has investigated the qualifications of Interblock USA LLC and has determined that it meets the board's requirements for renewal of its table game distributor license. Specifically, Interblock USA LLC and its principals continue to meet the qualifications for a license set out in Title 8, Section 1016 and 1019, and meets requirements of Board Rules, Chapter 2, Section 4. Therefore, after my verification of the documents submitted, interviews or inquiries, the financial review by Whipfly, and the final review by Director Champion, it is the opinion of the department that Interblock USA LLC is suitable to be continually licensed as a table game distributor in the state of Maine.
Thank you. Any questions for Detective Armstrong? All right. Any member of the public have any comment? Nothing in the room, anything on Zoom? Okay. Is there a motion on the application of Interblock USA LLC for renewal licensure as a table games distributor?
Motion to approve, March.
Thanks.
Seconded hand slip.
Okay. Any discussion needed from the board? All right, let's take a vote. So we'll start. Ms. Bickmore is on.
Aye.
All right. Chief March,
Aye.
Mr. Hanslett,
Aye.
I'm an aye as well. Having met all the requirements of licensing pursuant to Title 8, Chapter 31, Interblock USA LLC will continue to be licensed as a table games distributor in the state of Maine, and we thank them for continuing to do business in Maine. So with that, we will turn to unfinished business. Going back to the review of the facility-based monitoring system comments, fourth publication. On track to set a record here. Let me pull that up. And I don't know, Milt, do you want to set the stage as to where we are here?
Yeah. So we had two respondents, GLI and Oxford Casino. And I put everything from the fourth publication in red for easy review in the basis statement. So essentially what we're approving today is first and foremost the basis statement. And then if there's nothing major substantive to where we would have to publish it for the fifth time, then I think we can move towards final adoption. The comments started out on page 5 of the document. Oxford is looking for a little bit of clarification. There was a couple of responses prior to this fourth publication. And here, Oxford Casino recommends the following, and they stated to take out installed in and remain, or leave it to be locked in the machine or system rather than being installed in a locked compartment in the machine or system. And they had mentioned that the change seems to satisfy both the intent and the concern. The board's response to this prior to that is the board neither accepts nor rejects this comment because the comment does not require it. The board observes that this issue is already covered by the rule text, which allows the locked compartment to be in the machine. And so that's the current response. So it'd be left up to the board as to whether or not you want to make this change or just keep it the way it is.
Yeah, I mean, I guess if we have the response that says that the rule doesn't require, right, the compartment piece, then I think that would satisfy everyone's concern. I mean, you could always point to it, right? If there's ever an issue, you say, well, you said it didn't require it. So, I think leaving it as is seems fine.
So accept the change.
Well, yeah, I mean, either way, it's sort of moot, right? But yeah,
If the way it reads currently requires it to be locked in a compartment, locked inside the slot machine. That's not the way it's actually done. It is
Yeah.
locked inside the slot machine.
and as I'm reading it, our view is it actually doesn't require the compartment. But I mean, if we make the change, can we make their recommended change without having to republish it?
Oh, of course, yeah. So you can accept that change.
Yeah, so I say
we
just
should.
accept it.
And we should.
It provides clarity. Yeah. Just trying to avoid another republication.
Yeah, it is. I
Thank you, sir.
Okay,
I agree. Does that need a vote
No, not yet.
No, make the change.
as a group?
Yeah. All right, the next chunk of things are a lot of GLI recommendations, Mill, in the following pages.
Yeah, so pages 6 through 16 was basically a duplication of prior publications where GLI recommends removal of certain areas because they already comply with sections of GLI 13 or some of the other standards that we've already incorporated and adopted. I would say that, if you look into the GLI standards, some of the things that are commented within each one of these standards are things like to distinguish between local public policy and independent test laboratory criteria. It is up to each local jurisdiction to set public policy with respect to gaming. And then there's some others and these are statements made actually in the GLI standards, which is nothing wrong with it. I'm just wanting to bring it to your attention. Autoplay shall be securely controlled using a jurisdictional program that either allows or disallows the feature reflective of jurisdictional preference. So while they do have GLI standards, in those standards, they do point a direction to policy made by the local jurisdictions. In either case, the player interface terminal, as an example, must meet the hardware and software requirements outlined within each jurisdiction's applicable requirements for gaming devices to ensure security and player safety. In the absence of those jurisdictional specific requirements, GLI 11 requirements should be used. So I guess what I'm getting at is I understand that it would eliminate a lot of wording, but it would also take out policy that maybe you want to have control over.
And doesn't,
in addition to the standards.
I mean, in theory, could we do what we want? I mean, we don't have to adopt GLI standards.
That's correct.
Yeah.
That's correct. That's why, even though we've adopted GLI standards for the certification of slot machines for the use of, and then there's many different types of standards. There's progressives, there's kiosks, there's all the other standards. But I think they're basic standards for certifying for use in Maine. And then in addition to that, and as referenced in the standards, they always, they'll point to the jurisdiction and say, well, we're going to do it this way. But if you want to, you know,
So isn't that
specific to
some-
your jurisdiction, you could certainly do that. So,
Yeah, so isn't that, if we accepted all these, wouldn't that just be redundant as they point back to us?
well, it would take a lot away from what we currently have and would direct everything to the standards.
So the proposed response is that we reject them.
Yes.
Okay. All right.
Yeah, I think we can live with our own policies and like I said, they, you know, in their standards, they ask you to look at what's the jurisdictional preference. So I think for right now, I think we can leave it alone.
All right, then I'm
That's fine.
looking at page 18. There's a comment from Oxford about malfunctions.
Okay. So we're okay with the GLI one?
Yeah.
Stay the same response. Okay, very good. Yeah, page 18, Oxford Casino recommends in L, a slot machine or progressive slot machine shall not be enabled to play following the receipt of any critical function error. And they wanted the error, the word error take removed from there until the control program is authenticated. The board initially, with the comments that you'll see up above them in black, the board rejects the comment, makes no change to the proposed rule text. The use of the term any error is intended as an all-exclusive term. So again, that would be up to you as far as wanting to take away
So,
the
yeah.
word error.
So I understand the comment, right? The example they gave is, you know, it's a simple printer jam that occurs on a Sunday. Then the machine wouldn't, their reading is the machine wouldn't be able to operate until an inspector cleared it on Tuesday. But didn't we change it such that?
Yeah.
You don't have, if it's that, right? If it's a printer thing, a mechanical thing, you don't need the inspector?
No,
That-
they have communication. Good.
Yeah.
So to clarify on this is something that you brought up in the last board meeting about what type of errors are caused this issue.
Yeah.
Also, Eric Franklin, sorry. So we added critical to this because we're looking at something outside of the GLI scope of reference. So the machine had a major issue that pretty much we're probably gonna have to take the machine out of service and send the board off for forensics. That is a critical error where we would need permission from the state to bring that machine back up and running. But any error could be anything, printer jam, BB jam, anything like that.
But
So
but my
we're trying
understanding,
to clarify those two instances.
my understanding of what we previously worked on in the rule is that if it's something like these more simple issues, you send an email saying, hey, this happened, fix it, turn it on. They don't need, like, if it's at 3 a.m, you don't need Milt to respond, right? You can just do it.
We probably have 100 or 200 of those errors a day. And this requires being authenticated. Yes. So I don't think he wants 100 emails a day on every printer jam.
Yeah, I mean, what's your take?
No, but I think what the chair is saying, at least it's been my understanding, is no matter, day or time or whatever, if you have a communication issue or if you have something that's minor, you put together a work order, you go in, you fix it. And then if it involves like breaking the tape, then, irregardless, we should get a work order so that we can follow up and verify what was done.
What we're trying to say is that happens about 200 times a day.
Yeah,
So you want 200 work orders every day?
no.
Okay, that's what we're trying to clarify. is-
Okay, I see.
Because you're saying any malfunction, which is hundreds a day.
It's
Yeah.
critical.
So we're trying to say is what's a critical malfunction that you need to be alerted to, and what is a minor malfunction that a floor attendant's gonna go out, open the door, give the patron their bill back, shut the door, and off they go.
Yeah, well, yeah, those we wouldn't get contacted on.
So that's why we wrote this up, to divide those two out of what's a common error that we fix every day, and what is a critical error that we can contact you guys about, a RAM clear, a GLI issue, something that's extreme.
Right.
So
So with removing if the word error, I think we've resolved it. Right? Because we already talked about, we already have a definition of critical.
do we?
I don't think,
I don't
but
think
we created it.
I don't think we do.
Yeah.
So that would be my
Because you just
suggestion.
have manufacturer error, malfunction error. We remove the error and add critical in front of it and give it a definition of this is what a critical error is.
Or malfunction,
Malfunction, yes, sorry.
which I think is prudent because
Yeah.
definitions are always great to have. They
Um,
lead up to ambiguity.
so can we accept that change, that definition?
Yeah, you can add a definition to the definition section. I don't think that will require republication. But you don't have to accept this particular definition. You don't have any opinion on the definition.
Yeah, you also don't have to define critical malfunction.
Exactly.
And then it's sort of up to interpretation.
Right.
Yeah, I'd like the path of least resistance. So if adding a definition is going to require republication, then perhaps we don't add it in now. We can take that opportunity at a later stage, because I'm sure this will be touched again within the next year or two.
That's up.
But if we just have it read critical malfunction, seems to me that everyone was understanding
Yes.
it's not these things, right? That whatever, the bill isn't in or it prints the ticket, I don't know, this happens frequently.
Mhm.
I've experienced it, not at Oxford, but just in general. So I think this is my proposal, is we adopt the language, right? Slot machine or progressive slot machine shall not be enabled to play following the receipt of any critical malfunction until the control program is authenticated. And let's see how that plays out. I think we could revisit defining critical malfunction, also because the definition proposed also leads some subjectivity to it. Just says, then it becomes what's a normal day-to-day operational malfunction. I mean, we could go
Oh, yeah.
down a pretty deep chain. So let's add critical, right? Malfunction, take out error.
Mhm.
I think everyone's on the same page. To the extent there's problems, right, in operation, then they'll be brought back and we can get with it.
Very good.
Okay, does that make sense, Mel?
Absolutely.
And I would note that you're accepting the change except for the definition of critical.
Yeah, so it's sort of accepted in part, rejected in part.
Exactly. Yep.
So we're accepting removing error.
That's right, but we're rejecting adding the definition.
Okay.
Very good.
And I mean,
And it-
right, we've been operating for 5 months and it's very clear. We've
Yeah,
been
well-
doing this for a while. It's just how,
But things happen and people change positions, and then you
Absolutely,
read the
yep,
definition.
yep.
You don't know.
Viewpoints change.
So let's see how this plays out.
Okay.
Operationally for a few months, and if there's problems, then bring it up.
sounds
Alright.
good.
Um,
And it's always easier to do rulemaking on one sentence than it is, 60 pages.
All right, then we get to sort of the bottom of page 19 to
Right.
20. What's your take on this, Bill?
Okay, so, I'm actually okay with, I think surveillance being notified when they only go into the CPU is really kind of what we're looking for, and I agree that, again, like Eric just talked about, the techs are in and out of those for paper jams and everything else. So as long as, if they have to go in the CPU door and all that, then there will be a surveillance notification. So I'm okay with accepting what they're recommending here.
Okay. Fine with me. Accept it.
Okay.
All right, we're at the bottom of page 22, top of 23. Looks like the comment was about striking associated hardware.
I agree with that.
All right.
Yeah, we're more interested in where the software is versus where a monitor button or a TV screen is or anything like that. We're just more specifically worried about the software itself. So,
Okay. So that'll be accepted.
Yep. And then the final one is on page 36.
All right. All right, so this is about linked progressive jackpots. Milt, what's your take on this?
I'm gathering we already removed the central site monitoring system provider, so I'm fine with it.
Yeah, so I mean, it's reporting the jackpot to that email address that's set up.
Yeah.
Yep.
I'm fine with accepting that.
When's the last time the IRS updated that threshold? Anyone know?
They've been,
Yeah, it's been a long time.
about it for a while now. It's been the 1,200 forever, but every once in a while I'll get an email and say, oh, it's going up to 5,000 or whatever they're looking at, but I don't know, they're having a hard time passing it or whatever they have to do.
Okay. All right, well, you took care of that.
We're good.
What's our vote to
Yeah, so,
adopt the,
right, you
basis
can
statement?
adopt the basis statements with the changes made, during today's meeting.
okay. Do we need a second vote to, or no, that's just, we
That-
adopt it.
You adopt basic statement, yeah, so you vote to adopt this, approve the basis statement and approve the rules. After the fourth vote. And the incorporations that are needed based on this.
Okay, then one motion or two?
Two, vote to approve the basis statement and vote to approve the rules as amended pursuant to
All right,
the
so
basis statement.
first, if someone wants to
You do
move,
it, you do it.
it would be to approve the basis statement that we've just discussed
From the fourth publication.
from the fourth publication.
So moved, March.
Seconded, hand slip.
All right, any further discussion needed? Okay, let's take a roll call vote. Chief March,
Aye. Here, Kel.
oh, Ms. Bickmore,
Aye.
all right, Mr. Hanslett,
Aye.
I'm an aye as well. All right, so that's taken care of. And the second would be to adopt the rule, the final rules with the incorporated changes from
Yep.
this latest round of comments.
Correct.
So moved, March.
Seconded, hand slip.
All right, let's take a roll call vote. Ms. Bickmore,
Aye.
Chief March,
Aye.
Mr. Hanslett,
Aye.
and I as well. All right, got that across the finish line for now, at least. All right, next up, you have a proposed rule for lab certifications.
Yeah, so the board inquired or asked me to come up with some criteria, i.e. rules, and then also an application. And I've been working with some of my colleagues in other states to get some of what they do. What I've found is there's only a few states that do like a registration. And the last one that I got a copy from from Nevada, Las Vegas. They have a registration for labs. So I'm looking at that registration. For lack of a better term, it is an application that they fill out that I think would be appropriate for our use. In the interim, as far as rulemaking, I've put together based on, I think there was 4 states that I looked at that had rulemaking on the criteria for independent labs. And the one I liked the most that seemed more suitable for Maine was from Iowa. And so we've incorporated that language into chapter 19-A. And it's had a legal review as well. So this would be our proposed draft to go into rulemaking as far as the rules are concerned. And then what I'd like to do is, because I just got the most recent applications from various other jurisdictions, is to be able to come back to the board at the December meeting and present to you an application. I will tell you this, it's not as daunting as the business end of the application. In fact, it's maybe 3-4 pages versus, however long the business entity is. So I will have that for you in December. But in the meantime, I think we can go ahead and start the rulemaking on the criteria if that's the board's position.
So with the vote, so you're looking for a vote to publish this for rulemaking, you'll get written comments that will.
Well, and that's the other thing. If you want to have a public hearing, I can do a
Not at
public
this
hearing,
point. Yeah.
but we can do the comments, yes.
Any questions about that? All right, well, I'll entertain a motion to go ahead and approve this proposed rule for rulemaking and put it out for public comment. Anyone want to move for that?
So moved, March.
Seconded Bickmore.
Okay, let's take a roll call vote. Ms. Bickmore,
I.
Mr. Hanslett,
Aye.
Chief March.
Aye.
I'm an aye as well, so get that out for comment. I'm gonna take the new business out of order. And let's go to the chapter 13 rulemaking proposed language.
Okay. So again, and this also had a legal review. And so these basically are the proposed rule changes for chapter 13, which would incorporate the ability for ADW, fantasy, sports wagering folks to become a part of the universal list. The one thing the VLA committee I wanted to make sure of is to make sure it was consistent throughout. So and the fact that the board oversees that universal list self-exclusion program. So we'll begin with this. Once these rules are adopted, then we'll have to individually go into fantasy and sports wagering and incorporate that language in reference to chapter 13. So basically we're looking as we just did with the lab certifications, we're looking to go ahead and publish this as a rulemaking package for written comment. And
Okay.
again, if you'd like to have a public hearing, we could do that as well, but it's up to you.
Let's get comments first. Right, we can always, it's
Oh, yeah.
probably the topic of your presentation,
can.
but
Yeah.
we can get comments and then decide if.
Today?
No, like, we put something out for
Mhm.
rulemaking. We get comments back and there's a flood of them, and we think, okay,
You want
maybe
a
we need a
public
public hearing.
You could do that, yeah.
Or you can always do a second roundup.
Or you can do a second,
Mhm.
yeah, it's up to you.
Well, and I'm not sure if it was ADW, I think it was, we had written comments first and then we had a public
Public
hearing.
hearing, you can do that.
So I think
Yeah.
we can do that.
I know we've done it in the past.
Yeah.
Still tricky to transition from, public.
Well, I mean, given the changes here, I don't know. I can't anticipate a ton of comments, but we'll see. So let's put it out for written comment.
I think there's not a lot of changes. It's really just identifying that it's
Yeah.
universal.
Okay. So I think the motion would be to publish the proposed changes to chapter 13 for public comment.
So moved, March.
Seconded Hanslip.
All right. Let's take a vote. Ms. Bickmore,
I.
Mr. Hanslett,
Aye.
Chief March.
Aye.
I'm an aye as well. So get that out too.
Moving along.
Let's do, I'm thinking we'll do the GLI report, and then we could take public comment and then we'll take a break and come back for the rulemaking presentation.
Mhm.
just so everyone's aware. So let's go to GLI at this point.
Okay. Oh, I was wondering, the look of this is scanned in, just the projector. We're good.
Yeah.
John Grau, GLI, Chair Silver, members of the board, thank you for this opportunity to talk to you for a few minutes. So this is the really quick summary of our inspection that we conducted in June of facilities. As you are aware, the central control system has been removed, and prior to that, we were asked to come up and perform an inspection at both facilities to basically form a baseline of the software for the gambling control unit. And the goal of the goal of the inspection was really do two things. Verify the software in all the machines at both facilities, and train the inspectors that were accompanying our people. And with the another goal of having a minimal impact gaming operations as possible. So plan. Plans of both properties were really similar. Oxford, there were about 300 more gaming machines. Hollywood asked us to conduct the inspection overnight, while Oxford asked us to do it in the early morning. At both facilities, we had 2 GLI inspectors accompanied by 2 GCU agents each, and we had great support from both properties. I'd like to thank you very much for that support. Because we wouldn't have got it done without the support we have for properties. The start date was the same for both properties, so we decided to do it in parallel, and we anticipated the inspection would take 2 weeks. So when we say inspect the software, what are we actually talking about? So the process that we used for most of the game machines was something called, typically referred to in the industry as GATT, and GATT is a protocol that's used to communicate from a device like a laptop or another type of device with the game machine, and it allows the device to interrogate the game machine and get a unique signature. Essentially, you can think of it as almost like a digital fingerprint of each piece of software that's running on that machine, and then we compare that unique signature against the database with the status of that software, and we confirm that yes, it's approved in the state. Good. So the typical process that we ran through every day was the properties would come up with a list of machines that were ready to be inspected for that day. The technician would open the main lodge doors on the machine. GLI inspector would then plug the laptop into the machine. They would then interrogate the machine using the GATT protocol and get a list of digital signatures for each of the control software. Then they would look at the status for that software to make sure that it confirmed what the status was. They document everything they did, including the signatures and the approval status. Then the technician would lock up the machine, and the GCU agent would seal back the logic box, and the technician would lock up the machine. So results. At Hollywood, we inspected a total of 623 machines. 19 machines were down due to some hardware issue. All of the software was approved for the state of Maine, except for 14 programs that we identified that had a revoked status. And we were successfully demonstrate the inspection methodologies to the GCU agents that were accompanying our people, and we completed on schedule. Oxford, pretty much the same thing, 956 machines inspected, eight machines had hardware issues that we couldn't inspect. We had 25 programs that had a revoked status. Everything else was approved for the state of Maine. Inspection methodology demonstrated the agents, and we actually completed ahead of schedule at Oxford. And after that, we were invited to come back up to train the other agents. So we set somebody up for 2 days in late June. We provided training on using the Verify Plus tool, as well that runs on a laptop. Use that to run GAT, as well as the GI 4000 Pro, and alternate methods to obtain signatures if you didn't have GAT, such as reading signatures just right off the screen of the machine. And completed on site each property for 1 day. Thank you.
So what happens with the revoked
The-
software?
It gets replaced out. I think it's all been replaced out already.
Yes.
And is that like, I guess in layman's terms, like
Yeah.
what is that? Is that just like an out of date software,
It's
or it's like an
it's
actual
software that-
game that?
It's software that was approved at one time, and then subsequently there was some issue that was found where it was decided that it should be replaced by a newer version of software.
And how, I don't know, have you done this in the past? You said you were brought up because of the transition. Like, how often should we be doing an inspection like this?
It's really your decision now. This form the baseline. You have internal procedures now for the agents to inspect the software. When I believe when the first software is first received the property, it gets inspected, and then if there's an issue, which you talked about before, you'll re-verify the software. Plus, I think we just set up that notification email that goes to Milt, Matt, and Vicky when the software status changes too. So
Yeah, because there's two statuses, if you will. One is non-mandatory revoked, which means essentially at some point it's going to become revoked and you have the option to switch that out now, non-mandatory. But then when it gets to revoked, they basically ask for you to change out or convert the software to the latest version. In some cases, it was described to me as far as the revoked software and finding it on the floor is it really depends on what's revoked. There might be something less data or not have anything to do with algorithms and payouts and all that sort of thing. And so that wouldn't be an issue. Now, if it does have something to do with payouts and percentages and all that sort of thing, obviously we would communicate with the facility and that would be removed right away. But if you go into a machine and you're not setting up your options that would be essentially under the revoked category, then you don't necessarily have to jump the gun and replace it right away. We are monitoring it now on a day-to-day basis. We do get notifications from GLI on any software that is either non-mandatorily revoked or revoked. And when I get those notifications, I send them out to the SLOC department heads for each facility and then all of our inspectors so they know if in fact they have these devices on the floor, then they know they can make the necessary changes. So this is being handled on a day-to-day basis now going forward. Yes.
Okay, great. Any other questions for GLI representative? All right, thank you. I learned a lot.
Thank you. Thanks, John.
Okay, let's just turn to public comment now in case any folks have to leave. Then we'll take a quick break. So, anyone got anything? All right, let's take a 5-minute break and then we'll come back. So we have a presentation from Assistant Attorney General Mantis.
All rise.
Okay, we are back, turning to, new business, part A, which I delayed is a rulemaking, process presentation from Assistant Attorney General Mantis. So turn it over to him, and I think he will be sharing some slides.
I'll share my screen.
Yep.
Thank you, Mr. Chair. Thank you, board members. So this presentation is on rulemaking, which is covered by the Maine Administrative Procedures Act. That's in Title V, Sections 851, sorry, 851 for 87.3. So there's two primary types of rules for rulemaking. Are major substantive rules, so there are routine technical rules. Major substantive rules are rules that require direct involvement by the legislature. They have to approve them. Most rules in the main agency world are routine technical rules, as are yours. There are some areas where you do need to engage in major substantive, but you haven't been there yet. So today's presentation is going to focus on routine technical. If we do encounter a situation where we have to engage in major substantive, there'll be slight variation, but of course, that's what our office is here for, to guide the board through that process. Within the routine technical rulemaking process, there are actually two processes. There's the standard rulemaking, which is 99% of the time, but the board, actually 100% of the time so far, the board has gone for 99% of agencies. But there's also consensus-based rulemaking, and we'll touch on that later on in the presentation. So the basics, you have to identify the need and statutory authority for a proposed rule. So there has to be a statutory basis for the rule. You also have to have a need for, so the board, the agencies cannot just create rules that are not supported by statutes enacted by the legislature. The next step is then drafting rule text, which is usually done by the board members, or individual members or staff. Legal requirements vary. Then the next step usually is the board will review the draft rule in open session and vote whether to publish the rule text. We did that today for proposed chapter 19A. When publishing the rule, the board should succinctly state the factual and policy basis for its proposed rule. Publication of the proposed rule done by the Secretary of State. Goes to appropriate newspapers, anyone interested lists. So that's usually like licensees or other individuals who have named themselves as interested persons to the agency. And you should be able to provide the text upon request. So how it's published, whether it's the entire rule or just a summary of the rules, depends on the medium of publication. However, the text is always available to anyone who wants to look at it upon request. There's a written comment period, so anyone is permitted to submit written comments about proposed rules within a set deadline. It's usually 30 days from the publication. Board can also hold a public hearing. You heard discussion of that today. So yeah, this is a time for giving public the opportunity to speak orally to the board. They can also provide written comments as well that could deviate or mirror their own comments. You don't have to do a public hearing. Again, it's do a written period instead of a public hearing. The next step would be review and consider all public comments in open session, which happened again today for the fourth time. One set of rules, which include both written comments and any comments made in a public hearing if one is held. So you need to respond to each public comment by accepting, rejecting, or accepting in part, or rejecting in part. It's good to provide an explanation. It's not always obligatory. You need to amend the rules, the rule text to correspond with the responses to the public comments, if so accepted. And then determine if the amended rule text is substantially different. So if today, for example, we accepted some comments that were that created substantially different versions of the text that was up for publication, that we'll have to go into, we have to republish. So when asking yourself whether this has been a substantially different amendment, then you would have to consider whether the changes are consequential, which means significant or important, good questions to ask, who or what is covered or altered, the change that benefit or adversely affect those affected by the rule. Would a member of the public or regulated entity who did not comment on the proposal have a would likely comment on this version? Would someone who commented on the rule be surprised by the change? That's a big one. I like to use that as a base benchmark. They'd be surprised by that change because it completely deviates from the original publisher. Always good to err on the side of caution and to republish if you feel that there has been potentially a substantially different change to a rule that was published or proposed to be published. If you republish, the board may limit comments to only those amendments made in response to comments. After a comment period ends for republished rule, the board considers the response to comments proposed to adopt the rules, again, if they're not substantially different. You saw that again today, chapter, if you remember, a bunch of chapters considering the facility-based monitoring system. So when you initiate rulemaking, return to Title V, 87A. So the agency shall consider the goals and objectives which the rule is being proposed, possible alternatives to achieve those goals and objectives, and estimated impact of it. You have to look at the principal reason for the rule. You have to provide comprehensive but concise description of the rule that accurately reflects the purpose, operation of the rule, physical impact of the rule, an analysis of the rule, and a brief summary of the relevant information considered during the development. So these things are memorialized in certain forms that are provided by the Secretary of State that are filled out by unit on behalf. So again, these are the useful steps when initiating rulemaking. Identify the factual and policy basis that you're addressing with the rules. Articulate as clearly as possible the policy goals for rulemaking. How will the change? How will the changes to the rule impact the regulated entity in the public? Identify which existing rules will need to be changed to affect the policy goals. If an existing rule chapter does not cover the topic, decide whether a new rule chapter needs to be created. That's something that happens within the unit when they're preparing, or our office preparing new rules for the board to consider. Identify who will be involved in drafting the amendments for the rule chapters to address the identified policy goals. Set up time for those involved in drafting the rules to meet more than one person to do the drafting. That generally doesn't correspond with how the board receives proposed rules. They may often come from the unit directly, or is conjuring themselves. However, sometimes agencies may have people who focus on rulemaking. For existing rules, they have a fiscal impact greater than $1 million. You have to provide a fiscal impact. Public comment period, that's the more important on the slides here. You have to obtain and evaluate relevant information from the public, and that's why we have this public comments and any other information reasonably available to the agency with respect to the relevant provisions in subsection 1. So you have to look at public comments and also any information reasonably available to the agency provided to the agency. So when adopting rules, the agency shall file the Secretary of State the information developed by the agency, except for emergency rules, which I haven't seen yet. Citations for 3 primary sources of information relied upon by the agency adopting the rule. That again, these are memorialized in certain forms that are provided by the Secretary of State that are filled out by the GC usually, and then approved by our office for completeness, making sure that all of the proper information is documented. Notice to the public, the regulated community is essential to rulemaking. MAPA sets forth the obligation, the requirements for notice. Notice required in the subsequent schedule are dictated by whether the board proceeds with public hearing or without. And failure to fly with certain MAPA requirements throughout the rulemaking process. I don't know why it's stuck here, but this applies generally. they can void the, so if they're not adopted correctly, they're not noticed correctly. That's a big one that can void the rules. Generally through litigation. Public hearing. When this is required, if the rules are major substantive, again, we don't really talking about those today, but we may encounter those. There are some rules that do require the major substantive process. Publication notice and rules required 17 to 24 days prior to a public hearing. So that is the deadline. Written statements may be filed within 10 days after the close of the public hearing, or within such longer time that the agency may direct. So they just give the right longer period of time to receive written comments at the close of a public hearing. There's no public hearings, pretty basic. It's a 30-day notice time period that counts. The board must consider all relevant information available. So that's the written comments, anything provided, attached there to. The board must address each comment as we did today, before publication. And you can also synthesize redundant or similar comments. So if you receive the same comment over and over again, different commentators, one particular issue, you can collapse those comments and provide a response that would cover all of those, as long as they're not nearly identical. You also have to concurrently adopt the basis statement, which you did today as well. That explains the factual and policy basis for the rule. The adopted rule must be consistent with the terms of the proposed rule. Again, they're substantially different. You have to republish. You also have to address specific comments in state's rationale for adopting any of the changes. So failure to adopt the suggested changes or drawing findings and recommendations that differ from those expressed about the proposed rule. So if you accept a change, it's the rationale is different from that of the proper comment that you need to provide additional. You have to adopt proposed rules within 120 days after the comment deadline. And our office must approve the rule as a form of legality within 150 days of the comment deadline.
Can I ask a question about that? Is it 120 days from each publications deadline or the very first one? Like, for instance, the
From
fourth.
the last.
Okay.
So.
Like,
you adopt-
rulemaking could take way longer than
Right,
120 days.
It's 100 days after the comment deadline, then you adopt the rules, but we're looking at the comment deadline, not the date of the adoption of the rules for that deadline. It is a little odd, and this is people up in our office sometimes too, because we also look at the comment deadline for our deadlines, which is 150 days. We have to approve the rule system for legality. You guys have to start over. So that's how that works. Generally not an issue we encounter. This is all being dealt with in terms. You just think the board has to concerned about, but we are concerned about it, especially 120 days. So consensus-based rule development. Just briefly, in case you're interested, this is something the legislature has carved out, 8051-B. You would have to establish a representative group of participants, usually board members and potentially, well, for sure, members of the regulated community, other interested parties, to advocate. Develop mutually acceptable ground rules for the rule development process to be written down. You have to disclose expenses to the agency resulting from the process. Give notice of meetings to the representative group and interested parties. You have to select a person to facilitate the meetings, chair. You distribute meeting minutes and materials just like you do for a regular board meeting. But the board retains sole discretion over the final language of the rule. You can submit the rule as a proposed rule or not. So whatever comes out of it, or at the end of the day, you can say yay or nay. Board must also keep a list of all meetings held and also a summary of minutes. The board must issue a description of the consensus-based process, an analysis of the decisions made therefrom, and to the extent to which consensus was reached on the decisions if the process results in a proposed rule. So if you go forward with this rule, you have to move on. But again, the board can, what came out of the consensus process. I've never been part of the consensus-based process. It's quite new. Never seen it before.
And does it, well, at least one board member has to attend? So that's the way
I
it works.
think, I believe, yeah, there has to be at least one.
At least one board member.
So regulatory agenda, notice of the legislature. Again, this is stuff that generally is covered by the unit, take care of this on behalf of the board, and also the attorney general's office ensures that this has occurred. So agency and staff has to submit to the appropriate joint standing committee, the legislature, secretary of state, a regulatory agenda. Okay. Which basically says, this is the areas of our statutes where we potentially plan to, engage in rulemaking. Oftentimes agencies will just submit a regulatory agenda that covers all of their statutes each year, just in case they have to engage in rulemaking. They don't have to go back and amend the regulatory agenda because that is filed prior to any rule. So it's hard sometimes for agencies to be clairvoyant. They may just cover the basics by just saying, hey, we may engage in rulemaking for all of these, under all of our statutory. And notice the legislature again, that's something that the agents, the unit would fill out. Other aspects, just to be mindful, when legislation authorizing a regulated activity requires that certain criteria be met for a license permit to be granted, you have to determine. And when the agency determines that performance standards will assist them in complying, or will assist the regulated parties in complying with criteria. But the standards should also be developed during the mix process. So our performance standards imposed on the regulated community. In other words, the board should really spell out what those standards are, contours of the standard, just so that the regulated community is not guessing. Fiscal impact, every rule proposed by an agency must contain a fiscal impact note. It's placed on the rule prior to the public hearing. These rules adopted without a hearing prior to the setting of notice under section 853. Fiscal note must describe the estimated cost to municipalities and counties for implementing or complying with the proposed rule, generally for gambling rules, which is not rarely a fiscal impact note. The proposed rule will not impose any cost to municipalities or counties. The fiscal impact note must state that fact. So the section does not apply to emergency rules. So oftentimes these forms that we fill out for the Secretary of State, most more often not, the fiscal impact say that there will be no fiscal impact. And that's it. That's the whole.
Thank you. Any questions for Assistant Attorney General Mathis? It's the first time I've ever heard about the consensus portion.
Yeah, it's interesting stuff. Again, I've never seen an agency engage in it, but it does seem like it might be worthwhile sometime.
Thank you. Sure. All right, I'll just open it up to public comment again. If anyone has anything to say. Seeing nothing on the Zoom. Board business, anyone got anything?
I'll just comment that on November 5th, I'll be attending a online webinar presented by Massachusetts, I think it's Department of Health, on prevention of problem gambling. I don't know if you received those emails of invitations, no cost. It's enlightening, relevant. Yeah. If there's anything of key significance, I'll report back to the board.
Okay. Anything else? All right, our next meeting is scheduled for Tuesday, December 17th, up here in Augusta. That, although you may have a new office by then, or?
We're working on
Okay.
it. Yeah, up in the front here.
Same building.
Same building.
Same building, different location. So, snow, viruses, civil war, whatever pending, we'll be out here. Keep everyone posted. So, with that, I will entertain a motion to adjourn.
So moved.
Seconded.
Thank you. All right, Ms. Bickmore.
Aye.
Okay, Mr. Hanslip,
Aye.
Chief March. You're outvoted. Reject. I as well. All right, 11:03, we are adjourned.
Roger that. That's good. Good timing.